Hello and welcome to another mind-blowing episode on your favorite channel, XRP Zone, that brings you the latest and most accurate news regarding XRP, Ripple, and the SEC lawsuit against it. Today, once again, we're here to present to you another major XRP update, which may have ended this feud between XRP and SEC, and in other words, this is going in the favor of XRP and citing the success of XRP. Before we get into the depths of this topic, make sure that you've liked this video beforehand, and also please don't forget to subscribe to our channel so that you may get the latest and most authentic news about XRP that's well researched daily. Let's not waste more time and get started. So according to finance feeds, Judge Sarah Netburns scheduled a telephone conference to settle the privilege dispute that has been dragging on since April. The SEC has argued its internal documents, which include the agency's discussions over the nature of XRP and ETH, are protected by DPP, deliberative process privilege. That has been dismissed before by the judge 2 times already, as the court considers those documents relevant to Ripple's fair notice defense. The result of today's hearing may well be a major win for Ripple. The defendants have recently explained that these documents will expose the agency's contradictions in its decision-making throughout the years, which proves that the SEC didn't provide fair notice that XRP could be considered a security. William Hinman's deposition has already provided a general feel that regulatory clarity is something lacking in the SEC's communications. Jeremy Hogan, an attorney friendly with the XRP community, has pointed out 2 bombshells in that deposition that could strengthen the fair notice defense. The SEC yesterday filed a motion to compel Ripple to hand over recordings of specific meetings. Ripple never informed the SEC that Ripple routinely recorded staff meetings until a key former Ripple employee testified to that in her deposition earlier this month, said the plaintiff. Unauthorized recordings will be investigated, and anyone found to engage in such behaviors may be subject to criminal sanctions, Judge Sarah Netburns said in a letter. John Deaton, lawyer for the nearly 20,000 XRP holders that filed a motion to intervene in the SEC versus Ripple lawsuit, has called his following to max out the conference call. The hearing is limited to 4,000 listeners. The SEC has already complained about the enormous popularity of these hearings. Given the high level of interest in this litigation, participation by thousands of investors has already proven incredibly disruptive to Judge Netburns' court conferences. Let's max out on the conference call, but give them 0 to complain about, John Deaton said. XRP holders have kept their promise and maxed out the conference call as requested by attorney John Deaton, proving how critical the lawsuit is for the digital asset space. The judge has reminded the audience that video and audio recordings or broadcasts are strictly prohibited and subject to criminal sanctions. Judge Sarah Netburns first asked about the SEC's aiding and abetting claim regarding the complaint against the individual defendants if Brad Garlinghouse think it relies on objective or subjective folk knowledge that XRP was a security in 2013, to which Matt Solomon replied that it had to be obvious to reasonable people. If the status of XRP was not obvious to the SEC until filing the lawsuit in December 2020, it could not have been obvious to Mr. Garlinghouse, Ripple's counsel stated. Matt Solomon then mentioned the SEC's use of the deliberative privilege process (DPP) argument to keep its internal documents from being handed over to the defendants. Mr. Solomon argued that the plaintiff went grossly overboard in regard to DPP and should be compelled to hand over those documents as requested by Ripple. Then, the judge moved to attorney Jorge Tenreiro, the SEC's counsel, and asked his view of the reckless standard for the aiding and abetting claim made by the plaintiff. Mr. Tenreiro first attacked Ripple's analysis and stated that specific, simple foreknowledge alone is all that counts. But was Mr. Garlinghouse's action objectively reasonable? The judge asked. The SEC answered with a subjective argument. He could sit before a jury and say he did or didn't know, to which the judge interrupted, but that's subjective. The judge asked again, and Mr. Tenreiro repeated himself, that is, not offering an objective interpretation of Garlinghouse's alleged aiding and abetting of an unregistered securities offering. Then the SEC counsel complained that Ripple wants to collapse everything into digital asset law and look at everything internally and swing the door open, which would be very damaging. Judge Netburns asked why the court can't look at that and if it needs to determine date on what was deliberation, or is it an ongoing thing. Mr. Tenreiro explained there is pre-decisional and a post-decisional process, and there are plenty of examples in the privilege logs to argue different concurrent deliberative processes. How am I supposed to know all that? The judge interrupted as she decided she would conduct an in-camera review of the SEC documents. Mr. Tenreiro advised the judge to exercise caution while stating it could be very prejudicial. Judge Netburns reminded the SEC the defendants won't be reviewing the internal documents, during the in-camera review. The judge will thus proceed with reviewing the SEC's internal documents on her own and then rule on the deliberative process privilege claimed by the SEC. The ruling should be made after September 28th. Not even this. Adding more to your knowledge, over 12,000 XRP holders, represented by attorney John Deaton, have filed a motion to intervene in the SEC versus Ripple and filed a lawsuit of their own against the Securities and Exchange Commission. The court ruling on whether the motion will be granted or not remains pending, but the lawyer has been gathering and sharing publicly what he called significant evidence for the two aforementioned lawsuits. On a recent Thursday, John Deaton shared on Twitter a video from Consensus 2019 on perspectives on SEC engagement concerning digital assets. Participants included Amy Starr, Chief of the Office of Capital Markets Trends in the Division of Corporate Finance of the SEC, and Dorothy DeWitt, General Counsel, Business Lines and Markets at Coinbase. DeWitt joined the CFTC later that year. John Deaton said if XRP holders get a chance to be heard in this case, this is some of the evidence he will be presenting on their behalf to show that regardless of whether XRP was a security in 2013 to 2017, it's insane to say that today's token itself is a security. He also provided some additional thoughts on the SEC official and the video. Amy Starr is likely one of the fact witnesses from the SEC that Ripple elected to depose in addition to William Hinman. Her name was brought up in the Hinman deposition. In the Consensus 2019 video, Amy states, "We have people that really understand the technology." Amy Starr states that at the SEC, we developed an expertise in blockchain technology and that at the SEC, we participate internationally. Why is all of this significant? 1. XRP was internationally recognized as a non-security. 2. The SEC was an expert and understood blockchain technology so well, yet it chose not to bring a case against Ripple or XRP for 7.5 years, even though it aggressively pursued others between 2017 and 2019. The XRP holders' attorney said, adding that this makes the decision to file the case on Clayton's last day even more arbitrary, capricious, and suspicious. John Deaton also pointed to the statements by Dorothy DeWitt, Coinbase's General Counsel of Business Lines and Markets, who made these comments 3 months after Coinbase listed XRP. Most significant is that we know Coinbase met with the SEC in early 2019 to specifically discuss Coinbase's decision to list XRP. It's very likely that Coinbase met with Amy Starr, who was a senior person in the division with oversight of novel securities, and later joined the FinHub unit at the SEC, he explained. Isn't it ironic that a huge piece of evidence that Ripple will rely on to establish its fair notice defense, that market participants reasonably believe that XRP is not a security, comes from a market participant that delisted XRP? He pointed out. Remember, the fair notice defense is an objective analysis. What did market participants believe? These updates from the XRP case and the community suggest that the case is going in favor of XRP, and in no time it'll be over and will burst and explode the price of XRP in no time. XRP may also take over the world of slow and sluggish local banking and change it into fast, efficient, reliable, and extremely affordable means of exchanging and receiving money around the world. That was all from today's video. Let us know about your views in the comment section below, and don't forget to subscribe to this channel. Thanks for watching this video, and we'll see you soon.